An unconstitutional judicial opinion is no more binding than an unconstitutional legislative act. That was Lysander Spooner rejecting judicial supremacy, the notion that basically a judicial opinion becomes supreme, binding law on anyone and everyone just because it is a judicial opinion. So on this episode, we're going to break down Lysander Spooner's great insight and warnings, which actually echoed the same kind of views from many of the leading founding fathers, all totally forgotten and ignored today. But ultimately, judicial supremacy is not just unconstitutional, it's tyranny. But first of all, before getting to that, welcome, and thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, March 24th, 2025. So let's get right to it. Starting off again with the notion of judicial supremacy, what we're talking about today. This is basically the view that the Constitution means whatever the federal courts say it means until the judges change their minds. Now, in essence, this puts judicial opinions above anyone and everyone. Congress, the president, the states, the people, and even above the text of the Constitution itself. And Lysander Spooner, in his great pamphlet or essay, A Defense for Fugitive Slaves, published in 1850, he pointed out, and as the text of the Constitution itself makes so clear, the supreme law of the land is the Constitution itself. He said, "The Constitution is the fundamental, the paramount law, and all officers of the government are sworn to support it." Now, for Spooner, a judicial opinion on its own doesn't have any kind of magical power. It only gains authority, maybe supremacy, when it aligns with the Constitution. He said a judicial decision as such has therefore no intrinsic authority at all. Its constitutional authority rests wholly upon its being in accordance with the Constitution. So in other words, just because the Supreme Court issues an opinion, it doesn't automatically make it constitutional. Doesn't mean that they're automatically right. The judiciary, the judges, are just as capable of violating the Constitution, of making mistakes, as anyone else in Congress, the president, and anyone who takes an oath to the Constitution. Spooner said, "There is not a syllable in the Constitution that makes a decision of the judiciary of its own force and without regard to its correctness, binding upon anybody, either upon the executive or the people." And he continued, if a judicial decision be according to law, it is binding. If not, not. And of course, he's recognizing that the Constitution is the paramount law, the supreme law of the land. So to be actually law, it has to be in pursuance of the Constitution. Now, replacing constitutional supremacy with judicial supremacy, opinion supremacy, creates a system actually of total and absolute power. There's no limit to what the courts can declare to be constitutional. He wrote, "If a judicial decision contrary to the Constitution were binding simply because it were a judicial decision, the judiciary could constitutionally make themselves absolute sovereigns at once." In other words, this would create the very system that the founders, the old revolutionaries, fought a long, bloody war to secede from. This would transform the judges into a kind of a permanent class of unelected rulers wielding absolute power. He said, if we take the decision of a judiciary, as authority for the meaning of the Constitution, all decisions will of necessity be constitutional. And the judges are, of course, constitutionally speaking, absolute despots. Now, Spooner wasn't just making this stuff up. He was actually reiterating what a bunch of leading founders said decades earlier. For example, from this guy, someone we think of as being on the opposite end of the spectrum from Spooner, Alexander Hamilton, writing in Federalist number 78. There is no position, wrote Hamilton, which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. Now, he was speaking in this particular example about legislative acts. Contrary to the Constitution, of course, they're invalid. But every part of the federal government is, well, an agent of the people of the several states. They're only exercising delegated authority from the people. And if they can have final say over what the Constitution of the people of the several states means, then you're flipping the whole thing upside down. Hamilton put it like this: to deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. Also on this line, we have James Madison in his report of 1800 reminding us that the authority of constitutions over governments and the sovereignty of the people over constitutions, so he's reiterating that same food chain. It's government at the bottom, constitution rules for government, coming from sovereignty, the final authority of the people at the top of the food chain. So again, the authority of constitutions over governments and of the sovereignty of the people over constitutions are truths which are at all times necessary to be kept in mind, and at no time perhaps more necessary than at the present. Now, the founding generation repeatedly reiterated what we were talking about earlier: constitutional supremacy. Here's St. George Tucker. In his view of the Constitution of the United States, he said acts of Congress to be binding must be made pursuant to the Constitution. Otherwise, they are not laws, but a mere nullity, or what is worse, acts of usurpation. And despite what you may have heard about it, even Chief Justice John Marshall, in that very famous case in 1803 of Marbury versus Madison, took the side of constitutional supremacy and nowhere claimed to be taking on judicial supremacy. Judicial review and judicial supremacy are totally different. First of all, from Marshall, he said, in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. And Marshall continued, thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. Now, I covered the myth of Marbury versus Madison, the difference between judicial review and judicial supremacy according to Marbury versus Madison in an episode just this last month that will be linked to in the show notes. Marbury versus Madison exposed the shocking truth behind judicial review. Now, the founders certainly understood that courts could be wrong. And if you read what Marshall said, the courts, as well as everybody else, are bound by the Constitution. That means the Constitution is superior to all the branches of government. Here's Thomas Jefferson talking about judges in a letter to William Charles Jarvis. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and the privileges of their corps. And he continued, the Constitution has erected no such single tribunal, basically a single tribunal to determine what the Constitution means, because the founding generation understood that everyone who takes an oath, well, they can be corrupted by the nature of power and human nature. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with the corruptions of time and party, its members would become despots. It has more wisely made all the departments co-equal and co-sovereign within themselves. And James Madison emphasized this same view that the judiciary can make mistakes. And if you don't think about that in the structure of how you defend and define the Constitution, well, you're going to run into a lot of problems. Madison, in his report of 1800, discussing his Virginia resolutions of 1798, he said, the resolution supposes that dangerous powers not delegated may not only be usurped and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Now, from here, Lysander Spooner then takes us to the next logical step. Since unconstitutional judicial opinions aren't legally binding, the people then, of course, have a right to resist them. He said an unconstitutional judicial decision is no more binding than an unconstitutional legislative enactment, and a man has the same right to resist by force one as the other, and to be tried for such resistance by a jury who judge of the law for themselves. Little tip of the hat for jury nullification to protect the people, of course, resisting those unconstitutional acts, because just resisting it doesn't mean that government is going to back down on its own. That's a quick side point. And Spooner continued with this same principle in his essay on the trial by jury in 1852 regarding everyone who takes an oath to the Constitution. For them, the resistance to an unconstitutional judicial opinion is not just a right, it's not just a good idea, it's actually a duty. He said this, the executive has a qualified veto upon the passage of laws in most of our government. So the executive could veto and then maybe be overridden. But the executive has an absolute veto in all of them upon the execution of any laws which he deems unconstitutional, because his oath to support the Constitution as he understands it forbids him to execute any law that he deems unconstitutional. So if you take an oath to the Constitution, it's your duty to do your best to follow your oath. You're not taking an oath to the opinions about the Constitution of anyone else. If the founders wanted that to be the case, that's what the oath would read in the Constitution. It would be totally different. Now, I know I'm mentioning a bunch of original source documents, plus two great essays from Lysander Spooner, his defense for fugitive slaves in 1850, his essay on the trial by jury with that quote in 1852. These will all be linked to in the show notes. Alan Mosley normally does this, but we give him a little vacation time here and there, so we're grateful that he can rest and recharge and hang out with some friends, and he'll be back for the next episode. So basically, we'll get this it'll be me getting it organized this time, which means it's possible that I'll get the blog post for this episode published a little bit later than we normally get done because Alan is so on top of it. Anyways, that'll be over at 10thamendmentcenter.com/path-to-liberty, all spelled out, where we have all of our episodes. And in that blog post, you're going to find not just all the different platforms we're on, but there's going to be a show links section, which includes all the reference links that I'm mentioning in this episode. Pretty close to how I go through it in each episode, in the episode here. So again, 10thamendmentcenter.com/path-to-liberty. Now let's get back to this. We get plenty of this same message about a duty for people who take an oath to the Constitution to, well, resist encroachments on the Constitution, whether it's done by another branch or, well, who knows? Here's John Jay, the first Chief Justice in 1792. He said that by the Constitution of the United States, the government thereof is divided into three distinct and independent branches, and that it is the duty of each to abstain from and to oppose encroachments on either. It's not just a good idea, it's a duty. And here's Thomas Jefferson in a letter to Spencer Roane, 1819. Each of the three departments has equally the right to decide for itself what is its duty under the Constitution, without any regard to what the others may have decided for themselves under a similar question. And that's Jefferson just taking the oath seriously. Again, if you take an oath to the Constitution and they choose you to be in office for how you've explained how you're going to exercise that oath, well, then you need to do it, even if everyone else, even if you're alone, if you're the only person And there's a whole process. Checks and balances would mean if the representatives of the people don't want you there, they might impeach and remove you. So that's how it's supposed to play out. And that's how Jefferson, of course, described it as well. St. George Tucker hammered home that same duty, like Lysander Spooner put it, a duty to resist because you take an oath to the Constitution. Here from View of the Constitution of the United States, he wrote, acts of Congress to be binding must be made pursuant to the Constitution. Otherwise, they are not laws, but a mere nullity, or what is worse, acts of usurpation. Now, elsewhere in that book, usurpation, first of all, this is basically a theft of power from the people. If the people are the source of all power, they're the ones who hold sovereignty, and government is merely their agent just exercising those powers delegated to them. When government goes beyond those limits, they are stealing power. This is a usurpation. This is one of the terms in the Declaration of Independence. We often call them grievances, but they're really abuses and usurpations, or injuries and usurpations in the text of the Declaration itself. Tucker didn't hold back on this. He specifically said usurpation by government is really an act of treason against the sovereignty of the people. So treason against the final authority of the people, not necessarily punishable as the same treason in the Constitution, but I think that's an important point because when they go beyond the limits, this is a serious business. And Tucker put it like this: the people are not only not bound by these acts of usurpation, but the several departments and officers of the government, both federal and state, are bound by oath to oppose them. If you take an oath to the Constitution and someone else in government does something that's violating the Constitution, it is your duty to take action to oppose them. And that doesn't mean just talk about it. Tucker put it like this: for being bound by oath to support the Constitution, they must violate that oath whenever they give their sanction, by obedience or otherwise, to any unconstitutional act of any department of the government. Any department certainly includes the judicial department. Now back to Alexander Hamilton in Federalist number 78, where he forcefully emphasized that the judiciary is actually supposed to be, at least in his view, the weakest of the three federal branches because it can only say things. It can't actually implement what it wants to do or what it says. He said the judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. And if you think about that, if the judiciary is really nothing to fear, because he's arguing against anti-federalists like Brutus, who's thinking, oh, wow, these people are going to have way too much power. And Hamilton's responding by saying, look, you may think that, but they could issue all kinds of opinions, and their opinions can do nothing to anyone unless somebody else comes along and helps them, specifically the executive branch. And this obviously means that the executive, the president, might choose to not enforce the views or the opinions or the decisions of the judiciary. And he was far from alone on this. This is also stated by someone like James Wilson, who was one of the first associate justices on the Supreme Court. He said the president of the United States could shield himself and refuse to carry into effect an act that violates the Constitution. He's not saying he might refuse to carry into effect an act that a judge says violates the Constitution. No, he just may make that choice because he's taking an oath based on his understanding of the Constitution. And one of the prime securities that we were told about of the constitutional system is the fact that the executive branch may choose to not enforce a judicial opinion that is seen as unconstitutional. Here's back to Tucker. If we consider the nature of the judicial authority and the manner in which it operates, we shall discover that it cannot of itself oppress any individual. I mean, words may be violence to some people, but not to the founders, especially if it comes from a judge. a judge may issue all kinds of opinions, but it does nothing to anyone unless someone else comes in and enforces it. He said, for the executive authority must lend its aid in every instance where oppression can ensue from the decisions, whilst on the contrary, its decisions in favor of the citizen are carried into instantaneous effect by delivering him from the custody and restraint of the executive officer the moment that an acquittal is pronounced. And Tucker said, herein consists one of the great excellencies of our Constitution. That combination is one of the great parts of the Constitution itself. Now, if you want to learn how President Thomas Jefferson put these principles into practice against the hated Sedition Act of 1798, you're in luck, because of course there's a Path to Liberty episode, Oath versus Censorship, Jefferson on the duty to stop unconstitutional laws. That'll be linked to in the show notes when I get a chance to get to it, but sometime later today. When Spooner wrote about these principles in the 1850s, he was just repeating and reiterating what we learned from so many leading founders, from Madison to Hamilton, from Jefferson all the way to Chief Justice John Marshall. They consistently made the point that the Constitution is supreme, and it's actually a duty to oppose acts that go beyond those limits. So if you think about it, if a judicial opinion is law just because a judge says it's law, we don't actually have a constitution. That's a big warning that we got from Lysander Spooner, and from his work, we get 5 key points. First of all, the view that judicial opinions are binding because they're judicial opinions is the definition of tyranny. 2, instead, the Constitution is supreme, not the opinions about the Constitution from anyone. So 3, judicial opinions are binding only when they're in accordance with the Constitution itself. 4, every member at every level of government, federal, state, local, they all take an oath to the Constitution, not to the opinions about the Constitution of anyone. And 5, refusal to enforce unconstitutional acts, unconstitutional judicial opinions, unconstitutional executive orders, unconstitutional anything, isn't just a good idea. It's required by their oath. And I think Spooner nailed it best with this. He said the idea, so constantly asserted, that the permanent judiciary, the judges, have a right to decide all constitutional questions authoritatively for the people, is one of those gross impostures by which men have always been defrauded of their rights. Lysander Spooner was right. Judicial supremacy is not law. It has no basis in the Constitution. It's tyranny. Like pretty much anything that has to do with the original legal meaning of the Constitution, the government-run schools never teach any of this stuff. And that's why we work so hard every single day here at the TAC to reach and teach more and more people about this essential history, about these crucial principles. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that quickly devaluing dirty government fiat, please consider throwing it our way over at 10thamendmentcenter.com/members. It's all spelled out, 10thamendmentcenter.com/members. Our membership program starts out at just $2 a month. We also have annual, 5-year, and lifetime options. Again, 10thamendmentcenter.com/members. Or if you prefer to make a one-time contribution, you don't want to be a member, or you are a member and you want to help us out more, whatever it may be, I'm very grateful for that. You can pitch in a one-time gift over at 10thamendmentcenter.com/donate. I should mention here as well, I'm not going to do a show on Wednesday. I'm shifting actually to 2 shows a week, and I'm not sure what day they're going to be, but we're going to definitely have another show on Friday at our regular time, 9:30 a.m. Pacific time for the live stream, and of course, archived all over the place, video and audio versions. But you can help us spread the word by taking action on whatever platform you watch or listen on, especially if it's one of the big mainstream ones, hitting the like button, leaving reviews on Apple Podcasts or any other podcast platform, subscribe, get notifications, comments in the archive on platforms like YouTube. Watch time percentage helps out a great deal. 70% is decent, 120 is awesome, 200% is even better. I'm sure you get the idea. So I'm very grateful for any consideration you can give to supporting us financially or otherwise, or a combination of the above today. And I really appreciate you spending some of your time with me. I hope you enjoyed this episode. I hope it was interesting. I hope it made you think. And more important than anything, I hope you learned something. And I look forward to seeing you next time here on the Path to Liberty.